and we will get underway. So welcome, Sir Gerda Pujol. I'm muted. Or I apologize for that. We got disconnected. So I'll just, we'll start again at the beginning. Let me hit record. And let's see here. I do have a backup device just in case. So if this happens again, oh, I think we are recording right now. Okay, great. So it looks like we're still recording. I'll have to see if I can figure out how to edit this miscue. But let me introduce the subject by actually stepping away from the world of Tiger King. And I want you to go back to July of 2004 and pretend you're a venture capitalist and someone comes up to you with an idea for an investment. Sean Parker. Sean Parker is of dubious reputation. He's the co-founder of Napster. Although Napster was a successful company for a short period of time, the business model was unsustainable from a legal perspective, and the courts effectively ended up shutting your business down. So Peter Thiel comes to you and says, look, I have an idea. There's this social media site called Facebook for college students. Has a few, approaching 100,000 members. We'd like you to invest $500,000 in this venture. And so what I'm going to show you is a film clip of Peter Thiel, who is in fact the first outside of an investor, explaining why he invested in Facebook. Now, I do want to back up and say that I'm going to apologize in advance for a couple of things. The beginning of the interview is going to, the guy conducting the interview is going to say, hey, how did you pick a winner like Mark Zuckerberg, right? And you have to understand the interview was way back in the day when Facebook was about to go public, and shares were going to be listed on the NASDAQ exchange in New York City. At that time, Mark Zuckerberg was something, very popular. Today, I don't think we would call him a winner, though his company is very successful. But he's taken a lot of hits. And so, that's a little bit dated. Probably we would use a different adjective to describe Mark Zuckerberg today. Also, I'm going to also apologize in advance that Peter Thiel comes across as a smug and pretentious and arrogant prick. I'm just going to go ahead and say it, So I really apologize for that. But nonetheless, some of the things that he's going to say in this short video clip I'm about to show you are so important that I want you to put aside this guy's just obnoxious demeanor. I want you to put aside your feelings about Mark Zuckerberg, and I want you to listen to what he has to say. And then on the other end of that video clip, I'll link it up to intellectual property law, what I call the law of ideas. So let me go ahead and do a short screen share hopefully we'll have no technical difficulties now. Um, let's see here. This is the Zoom. Let's go to the video. And then what I'll do, hopefully you're seeing the video. I'll go ahead and expand it and play it for your edification.
Spot a winner as big as Zuckerberg? Well, it probably would be somewhat misleading.
Again, remember, this is 2004, right? Nobody knows who Mark Zuckerberg is. He's taking a leave of absence from Harvard, right? He's didn't even finished his sophomore year. And so here comes Peter Thiel.
To say that all of this could be seen from the very beginning. I had looked at it already, a number of these different social networking sites, and there were definitely a lot of the early attributes were quite good. They seemed very competent technically, which is actually strangely not true of many of the other companies. But I think one of the other things to always I'm always very focused on this point is not just the product or the abilities of the people, but sort of the third part is what I would describe as the business model, the business strategy. And I think that's often not given enough weight because inventing something new is generally good for the world. It doesn't mean that you automatically will do well as an inventor. In fact, most scientists and inventors end up capturing disturbingly little of the value you create. To succeed as an inventor or scientist or entrepreneur, you have to create X dollars of value for the world, and you have to capture Y percent of X. And the one important detail people forget is that X and Y are completely independent variables.
I'm going to stop there because what you just listened to is, I'm going to tell you right now, is the single most important proposition that you're going to be exposed to in your college career. I mean, outside of, if you take philosophy or religion or English literature, some of those other great courses. What Peter Thiel is saying, look, it's not enough to go to Shark Tank and get somebody to invest money in you. It's not enough to have a good idea for a product or service, what he's calling the X variable. And I say that's actually, it sounds very trite and cliche, but it's actually, if you think about it, it's a little bit, it's more original than that, because he's saying, look, of course you have to have a good idea for a product or a service if you want to succeed in business. Whether you're an entrepreneur, you have an idea for a startup, or whether you're a Fortune 500 company and you're considering, launching a new product line or offering a new set of services, a new website or something. What he's saying is, in addition to having a good idea for a product or service, etc., you also have to figure out a way that idea is going to generate revenue for you. To use the jargon, which I hate, how do you monetize your idea? That's the Y variable. And that, to cut to the chase, is exactly where intellectual property law, what I'm calling the law of ideas, comes into play. This is an area of law. So I cannot emphasize enough how important this area of law is. It's not only the bedrock of sports and entertainment law, but it's really the bedrock of any successful business model. Does that business own valuable intellectual property rights? If it doesn't, that business really isn't going that far. It's not going to be able to scale up in any significant way. And so think about it. Every single product or service that you use, whether it's online or in the physical world, right, is going to embody a set of ideas. Whether you're talking about, a Ferrari Testarossa, one of the most beautiful designed cars in the world, or whether you're talking about the of the apartment where you live, or whether you're talking about your phone, your smartphone device or laptop, right? All products, whether you're talking about a bottle of Coca-Cola or a bottle of Tabasco formula or WD-40, oil, whatever, every single product and service we use embodies a set of ideas. And what the law of ideas allow you to do, that's why I call intellectual property the law of ideas. It allows you to either do one of three things: either assert ownership, exclusive legal ownership over the ideas you come up with if you satisfy certain requirements, or it allows you to assert ownership over the expression of your ideas, or lastly, also assert ownership over the branding of your ideas, the marks use to distinguish your products and services from those of your competitors. And so if you go, and I'm going to go now into module, module C, and let's go ahead and take a look at that. Let's see here. I'll go back into the web course. Oops. Let's see, I need to exit.
And that in most cases,
let's go back into web courses, and then what we'll do, we'll go into module C, and you'll see, I posted it right here. And what you're going to see is patents and trade secrets. You're going to see copyrights and fair use, and then you're going to see trademark law, which includes both, which is the branding part of intellectual property. So you're going to see three broad areas of intellectual property. By the way, in the module, I have some examples more specific to Tiger King, but in this live lecture, I want to take advantage and talk about some other things, like now Facebook, or I want to talk about Napster. I'm going to talk about a few other things, just to show you how important this area is. By the way, I forgot to announce earlier, there is a playlist of videos for this module. However, I have invited a attorney, a business lawyer from Denver, Colorado, Miss Aiden Durham, to give these lectures. I like her a lot. I like her informal style, and because I'm not a practicing attorney anymore, I'm a full-time academic. I wanted you to get exposed to someone else. And you see, there's different types of attorneys, different styles, different ways of learning the material. But her area of law is business law, and she represents a lot of startups. And this is you can see how important this area of law is. So you don't take my word for it. In addition, though, or I should say alternatively, if you prefer yours truly, I do have sort of an optional podcast that I recorded, so an audio format, where I talk about the law of ideas. And then I do have some blog posts that I have here in the intro of the module, and that I've sprinkled in each of these sub modules in here. Now, what I want to do, though, is just jump directly into the survey, and then because what you have to understand that copyrights and trademarks, those are upper level. Those are two separate upper level courses at the law school, graduate school level. Patents and trade secrets are usually taught together. Again, separate upper levels. So we're talking about here three, upper level courses. So what I'm going to do is highlight the most important ideas of the intellectual, of the law of ideas, intellectual property rights. And to do that, I want to go into the survey. And so if you haven't done it, I've extended it until 11:59 tonight. And what we'll do is, let me find quiz statistics, survey statistics, and we will let that load. And it'll take a little while as we, this is, we have about 900 students spread out over 5 sections. And so it does take a little while to load. And I don't want to load it yet. I want to give everybody a chance to do the survey if you haven't done it yet. So the first question is, and by the way, in Tiger King, there were some copyrights and trademark disputes, but really that's kind of, I don't want to say chump change, because Joe Exotic lost, and he settled for like $1 million, which is a lot of money to you and me. But I want to talk about probably the single most important piece of intellectual property, or a little bit of this way, the single most valuable idea probably in the annals of commercial history. And that's going to be the Google PageRank algorithm. So here it's interesting to see, that's a valuable invention or, idea. How does Google protect that idea? And so what's really interesting is that 58% said patent law and 42% here said trade secret law. This breakdown may be due to the fact, let me open up the modules again. That breakdown may be due to the fact that I have included Google's first patent in the modules, and I want to show it to you. But in fact, I want to tell you that although Google did patent the PageRank algorithm back in 1998, or it submitted the registration, the application for a patent. Google, subsequent to that, all the innovations or most of the innovations that Google has made to Google search, which is their bread and butter. I know Google now, Alphabet Inc. does a lot of different things, but all of the innovations and improvements and enhancements and new ideas that they've inserted into Google search, all of that is now Google prefers to go the trade secret route. So what I want to do is show you the patent and then explain the advantages and disadvantages of using patent law versus trade secret law to protect your ideas, inventions, formulas, etc. So let's go into the module again. I apologize. I thought I had it open, but when I got disconnected from the internet, a couple of the things got lost. But I'll pull it up really quick and see Google's first patent over here. So let's pull that up. I want to show it to you. It's worth taking a look at. And what I'll do is I'll just download it just so we can see it as large as possible. And let me see if I can make it even larger. You can see here that Larry Page is listed as the inventor. One of the interesting things, though, it says assignee. So the owner of the patent, the person to whom, or in this case, the institution to whom the patent was transferred to, the ownership of it was transferred to, was Stanford University. And then you can see here that this patent was filed on January 9, 1998. And this is actually the first important lesson you need to know, because it applies equally to trade secrets and to patents. That is, when you work for somebody else, or you're a student at a university like Larry Page was at the time, any invention that you come up with, within your scope of employment is going to belong to the person you work for, the company you work for. That's called the work for hire doctrine. If you want to get out of that, you have to negotiate that ahead of time. You have to have a contract in place saying, no, any discovery or invention that I make, while I'm working for you, I own it, not the company, not my boss, or not the company for which we both work for. But the general legal doctrine, the default rule is that, when you work for somebody else, you work for a company and you come up with an idea, an invention, a discovery that later becomes patented, or, the company decides to obtain trade secret protection, it belongs to the company, not to you. So that's an important thing you need to know ahead of time, Now, what's interesting here is that Larry Page was lucky that he was a student at Stanford, because what Stanford did is when he graduated, they said, look, we're going to give you, Stanford's attorneys, I should say, we're going to give you this patent back to you. We're going to reassign it to you. In exchange, of course, you're going to give us a percentage of whatever revenues, Google search eventually owns, right? So notice that's kind of a win-win situation, right? Larry Page wins because he gets his patent back. Now he, or the company he founded, I should say, back then it was called Google Inc. Now it's called Alphabet Inc. Google, just one of the wholly owned subsidiaries within Alphabet. But the point is that now Larry Page owns his patent, right? And that's going to make the company very valuable, because the company now owns the PageRank algorithm. And then Stanford is going to win because now they don't take any risk. If Google doesn't make any money, fine. But if Google does make money, they'll get whatever they negotiated with Larry Page, and Sergey Brin, his other co-founders. So now, why is it then that Google does not continue to use patent law to protect all of its subsequent innovations to the Google search, algorithm, if you will? Well, look at when this patent was filed, January 9th, 1998. And mind you, we're talking about probably, right, the single most valuable idea, since the wheel or the light bulb, right? This Google's probably, right up there with Apple, because they both own valuable intellectual property, right? But this has to be one of the most valuable ideas. Look how long it took Larry Page to get this patent prosecuted, which is the language patent lawyers use. You prosecute a patent, in order to get it approved by the United States Patent Office. Look, September 4th, 2001. We're talking about 3 years and 9 months to get the most valuable idea in the history of, commercial activity, to get patented. Patents, in other words, are very expensive and time consuming. This says it all. And why is that? Because to get a patent, you have to show 3 things. One, that your idea is novel. No one has come up with it before. You're the first one. Number 2, that your idea is useful. It has some commercial value. But the third requirement is the most difficult. You have to prove a negative. You have to prove that your idea is not only novel and useful, it was also non-obvious. In other words, that nobody else on the date on which you filed the patent, January 9th, 1998, given the state of scientific knowledge at that time, nobody else would have come up with this patent. Nobody would have come up with this idea for a patent. And this is very difficult to show because, back in 98, there already were many search engines, beginning with Internet Explorer, right? Yahoo Search and Alta Vista, So you're telling me that none of these other inventors or none of these other companies would have eventually come up with a method similar to the PageRank algorithm to come up with search results? That's kind of hard to prove, right? Eventually, somebody's going to figure it out, right? And I'll tell you, we don't have time to go into the substance of the patent. What's unique about the patent is that it uses a kind of, you see these like numbers here going anywhere from 0 to 1. Here we have basically 0.4 and 0.2. Basically, the PageRank algorithm is a probabilistic algorithm based on if you're searching for pizza, for example, perhaps previous search algorithms would, count how many times the word pizza would come up, right? In a website. Problem with that is that could be easily gained, right? Anybody, you can even put like some white font so nobody could see it, or a font the same color as the background of your website. You could just write the word pizza a million times, right? And no one's going to notice, right? Except the machine, the algorithm. So what Larry Page decided to do, along with Sergey Brin, is search results will depend on how many other pages link to the thing that you're looking for, and the more links that other people are linking to your web page, the more probabilistically that's the thing you're looking for, in terms of its relevance. So I'm trying to put it into words, but trust me, this was a novel and useful, but showing something is non-obvious, it took Larry Page almost 4 years to prove that, and that's why you cannot, I tell you, if there's one area of the law you cannot do. I've seen people defend themselves on death row, which is a huge mistake. But one thing you're not going to get, you could try to prosecute a patent on your own, but you're not going to get the patent. I'm going to tell you that right now, without the help of a patent attorney, because what the patent attorney is going to do is they're going to look up the state of the art. They have to tell the patent office what is the scientific knowledge on the date that the patent was filed, and then explain in the rest of the patent application. Here's some visualizations of the PageRank algorithm. Explain in the rest of the patent, and it reads like a scientific article. Explain why it is this whole thing is non-obvious as well as novel and useful. So it's very difficult. The other disadvantage of trying to get a patent. Now, if Stanford has lawyers and they want to pay for all of this, be my guest. Larry Page, that's probably why he did the patent route the first time, right? Because Stanford is paying for this. You know what I mean? But notice the other disadvantage of patents. Look at the date when it was finally granted. We already saw it. This patent is expired, right? It's a 20-year utility patent, right? And actually back then, I think it was only 17 years. So this thing already expired years ago, and even if it was a 20-year patent, it already expired last year, right? That's the opposite of a trade secret. Trade secrets never expire, and there's no formal legal filing. So you don't have to go to the government and try to prove that your idea is non-obvious and is worthy of patent protection. In order to get a patent, you have to do two things. Your idea has to be commercially valuable. So in patent terms, it's got to be useful. It's got to be something that somebody would want to buy or even steal. It has to be valuable. And number two, though, you have to take reasonable efforts or make reasonable steps to keep your idea a secret. And so what it generally means, courts generally require evidence that the owner of a trade secret has taken reasonable efforts to keep their inventions or formulas or ideas a secret. And generally that means you have to have some kind of non-disclosure agreement or some type of contract with the people that you've shown your ideas to, a contract ideally in writing that says, with the confidentiality clause, where the parties agree to keep the secret, and the contract specifies liquidated damages penalties for not keeping the secret. If you've seen the movie, I'll go back to Facebook one more time. If you've seen the movie, The Social Network, what's going on there is that, the Winklevoss twins allege that Mark Zuckerberg stole their idea for a social media website. And the reality is, don't overthink it. Zuckerberg stole their idea. There's no doubt about that. I mean, absolutely no doubt about it. Why did the Winklevoss settle the case? Right. That's why Zuckerberg settles, right? He knows he stole the idea, right? And I can show you there's a sworn statement by the Winklevoss previous computer programmer saying that, hey, I gave Zuckerberg the source code, but, he couldn't share it with anybody else. The problem is, although the Winklevoss twins have that testimony from their former computer programmer, they don't have anything in writing. You know what I mean? So, it's going to be up to the court to decide, do I have sufficient with the sworn statement by the former computer programmer? Can I send this to a jury? And I got to tell you, the Winklevoss case is not a frivolous one. If the judge, if I were the judge, I would send this to the jury and let the jury decide. These are all college students, so of course nothing is in writing. But Victor Gao seems like a credible, the computer programmer for the Winklevoss twins. He seems like a very credible witness, there's no reason to lie here. You know what I mean? He's already, ruptured his relationship with the Winklevoss twins. He's not getting paid by them, So, I believe him when he says that, Zuckerberg, I told Zuckerberg that, you're getting the source code to finish the Harvard Connection website on the condition that you don't share it with anybody else, Now, of course, Zuckerberg didn't share it really with anybody else, but he used the idea to develop his own website, right? So that's why the Winklevoss twins settled. Now, I'll say more about why cases do settle out of court. Even Joe Exotic, who hates Carol Baskin with a passion, and trust me, my TAs and I, we've spoken to Harold Baskin via Zoom. They, don't like Joe Exotic either. Even they settled their disputes out of court. So we'll see that in the next module. I'll say more about those lawsuits and explain why it is that cases settle out of court. So notice, right, with a patent, right, you do get exclusive legal protection, for a limited time, 20 years. But showing that your invention is non-obvious can be very, very difficult if you're trying to get a utility patent. There's something called a design patent, which is a whole different, type of patent. But here I'm talking about like real valuable commercial ideas like the PageRank algorithm. With trade secret law, but there's one more disadvantage with trade secret law, I should say. The advantages are that it's cheap, right? There's no filing, right? You just have to have a good idea and make sure that you have contracts with confidentiality clauses, right? Make sure you have non-disclosure agreement. You're gonna need a lawyer either way, right? But a lawyer to draft your legal Zoom, to draft you the relevant documents, with confidentiality clauses, probably is a lot more affordable than getting a patent lawyer, right? So trade secret law, even a company as big, powerful, and successful as Google uses trade secret law, every single day. But the main disadvantage with trade secret law, and by the way, trade secrets never expire as long as your idea is commercially valuable, and as long as you continue taking reasonable efforts, vigilant efforts to keep your idea a secret. The problem is reverse engineering is an absolute defense, right? So let's go, we're in the screen share modality still. So, let's go to Google really quick. And let me just pull up Google. Let's see if it'll let me do it. And let me pull up Bing, right? Let's pull up Bing. And you can see the two websites are very different, right? But what happens when we search something, right? So I'll search pizza, and then I'm getting this map over here, and I'm getting some search results. Oops, I'm on the map there. And I'm getting some, other related questions that could be relevant to the search. What happens when I search for pizza on Bing? Notice, right? I'm getting pretty much the same thing. I'm getting a map, and then, instead of putting the stuff on the left, these are the pizzerias that are indicated on the map. Look at this. I'm getting a lot of the same search results, right? And look, I'm getting the related searches. Notice what's going on there, right? Bing basically reverse engineered, right? The page rank algorithm, the Google search algorithm, right? But that's perfectly legal, right? If your engineering team can figure out, or if you yourself can figure out how the page rank algorithm works, or if you can figure out, what's in the Tabasco, Famous Amos cookies, the same way that Famous Amos makes them, if you find that out with your own efforts, that's perfectly fine. By the way, quick timeout before we move to copyright law. I did get an unstable internet connection warning, so just stay on the line in case I do get disconnected, and I'll use my backup device. All right, let's go on to the rest of the survey. And what I'm going to do here is pull up that survey and have that ready, and then let me do a screen share. Let's see here, the screen share. So many bells and whistles here. All right, so but by the way, before we do the other areas, this is a good refresher, right? We have these four main types of intellectual property, though I like to lump patents and trade secrets together because those are two different ways of protecting your actual ideas or inventions, etc. But I'm always curious to see who in the class, maybe owns intellectual property, or more likely than not, has created their own intellectual property. But notice there's two ways of obtaining valuable intellectual property. There's three ways, right? One way is you could do what Mark Zuckerberg did, is you could just steal it, right? And hope to get away with it, right? So that's what Mark Zuckerberg did when he, stole the idea from the Winklevoss twins, right? He didn't really get away with it because he had to end up settling out of court, etc. But, he paid, for what the idea was worth, he paid a small amount, right? The other way is you could buy the idea from somebody else legally. And that's what Zuckerberg, now that he's legit, that's what he does now, right? That's like when he bought out the right round, right? He bought that out fair and square. But that cost him, what, $5 billion in 2012 money, right? 2011 when he negotiated the deal. You know what I mean? As opposed to just stealing it and only paying the Winklevoss twins a few $1 million, right? But the third thing is you can create your own intellectual property, right? And like Larry Page did, right? When he came up with the page rank algorithm. Here are the results. Look right here. Let me put my glasses back on. Notice what's really interesting here. We have a significant fraction of the class. Oh, and by the way, notice there's a glitch. This is a survey. So everybody, I know the top answer always comes out in green, but technically all the answers get, obtain full credit. You know what I mean? I don't know why it looks that way. But, I have to tell you here, in fact, 100% of the class, everybody here watching the lecture, has created intellectual property, perhaps even valuable intellectual property, and the example I'll just begin like, it was Valentine's Day the other week. So if you wrote a love note or a poem or, you wrote a, little note in a Valentine's Day card, that technically, as long as you're not copying that from somebody else, you know what I mean? That is your intellectual property. The discussion posts, your profile picture, Every time you've taken a selfie, on your camera or on a, traditional photographic equipment, that is that's your intellectual property. The market will decide whether it's valuable or not, whether you want to buy it or not. And who knows, maybe you've come up with something that could be a trade secret, right? Maybe you have a formula or a recipe, or you have a list, like a list of potential clients that might want to hire you. If you go into the accounting profession, for example, a client list is considered a valuable trade secret. That's commercially valuable information, right, for clients. So, maybe you come up with an idea for a trademark. We'll look at that at the end of today's live Zoom lecture. So, the thing is, everybody has created some form of intellectual property or another. You know what I mean? I know I've even had students who have participated in a project, that eventually led to a patent application and the granting of patent rights. So that's possible. You know what I mean? So the idea here is that everybody is capable and has, in fact, created intellectual property. Now, whether it's valuable or not, and whether you use intellectual property law to, extract value of that for yourself or for your company, that's a different story. But I want to make it absolutely clear that, in fact, it turns out that everybody, in the class, everybody has created, especially nowadays where we all have smartphones, we all have, writing essays. And I'll tell you, the most common form of intellectual property is going to be copyright law. Copyright law, which is based on common law principles, but Congress did enact a Copyright Act, one of the first laws enacted by the first Congress way back when George Washington was the president of the United States. And as recently as 1976, Congress enacted a new comprehensive Copyright Act replacing the old laws. But this Copyright Act, this federal copyright law, is based on common law principles. And guess what? The common law says you don't have to register your works. Copyright law, we refer to not ideas, but works, the expression of your ideas, whether it be a poem, music lyrics, a musical composition like a melody, dance, choreography, ballet, sculptures, oil paintings, other forms of artworks, a movie, a documentary, a script, a short story, a novel, your memoirs, your diary, anything, as long as it's original. It's 2 requirements for a copyright. It's got to be original, not something you just copied from somebody else. It's got to be original. And, if it is based on someone else's work, that you've made enough changes that is considered original, and that work, whatever it is, you're able to affix it in a tangible medium of expression. I made up my own word here, affixability. Can that work? Can it be printed? Can it be recorded? Can it be filmed? So whether you can you write it down, print it out, audio tape it, video record it, whatever, as long as it can be expressed or affixed, to use the legal language, in a tangible medium of expression, that belongs to you the moment you create it and affix it to that tangible medium of expression. Now, you may have heard, do you have to mail it to yourself? Do you have to post it on Facebook? The reason why sometimes people say that is because how do you prove that you own a copyright, right? So if you mail it to yourself, assuming you're using registered mail, right? That's going to be a little bit easier to prove, that, yeah, you're the one, because this is the day that you mailed it, et cetera, et cetera. Or you post it to Facebook, Facebook will have a date stamp on it, but you're not required to do that, at common law. Now, the reason why a lot of companies, though, go to the trouble of a federal registration, and by the way, federal registration is a lot easier. We can go, actually, I think I have a link in the discussion post. You can go to copyright.gov, which is a website operated by the Library of Congress. You have to create an account, but it's free. And it's simple. It's a simple 1-page form, and you can upload the work or a picture of the work if it's a sculpture or something like that, that you want to, and it's a nominal fee, like $20, $25, depending on the type of work you want to copyright. The one advantage of registration, the two are, with registration, there is now definitive proof as to who the copyright owner is and when those ownership rights were established. Because federal copyright registration operates as a kind of prima facie proof as to who the copyright owner is. The other advantage is enforcement of your copyright. You can only go to a federal court to enforce your copyright if your copyright is registered with the Library of Congress. Then you're allowed to go into any federal court in the United States to enforce your rights. And that leads me to actually a third advantage of federal registration. At common law, you really only get protection in those areas, in that state in which you created the copyrighted work. At federal law, you get nationwide protection, right? So it's a huge thing. Now, there's one more advantage. You don't need to know this, but it turns out to be probably the most important advantage if you're a small business firm. The federal law does provide something that lawyers call statutory damages. The Federal Copyright Act has a schedule of damages. That is to say, if somebody does infringe on your works, on your copyright, and you happen to have copyrights registered, then guess what? The federal law will automatically award you, if you can prove infringement, will automatically award you $2,500 or something like that, for each act of infringement. You know what I mean? And so that can be significant, that can really add up really quickly. At common law, not only do you have to prove that you are in fact the owner, and not only are your rights limited to that state, this common law, state law, you've got to prove your damages. You've got to prove, that that not only was your works infringed upon, stolen, but that caused you some economic loss. And that can be very hard to prove sometimes, especially when you're in the startup phase and all of your revenues are still speculative, so to speak. The question here I have is, can you copyright a tattoo? And what's interesting before I get to this is that, if you look at the results, right, people overwhelmingly say, like 66, 2/3 of the class say that yes, you can get a tattoo. The Justice Elena Kagan position, if you go back to, although this has never been decided by the Supreme Court, it's an open question. But if you recall Elena Kagan's dissent in the case of Yates versus United States that we saw in Module A, Elena Kagan said, hey, a fish is a tangible object, So the Sarbanes-Oxley Act says if you destroy any financial record or tangible object, right, that is a crime. So a fish is a tangible object. So a tattoo, right, as long as it's original, right, not just copied from somebody else, and it can be affixed on human skin, right, tangible medium of expression, you could argue that tattoos are deserving of legal protection. But there's two problems with that argument I want to share with you now. And the two problems are, and again, the courts have yet to decide this. Most of the cases that have involved, ownership of tattoo designs have been settled out of court. And we'll say more about that, why people like to settle instead of taking their chances with a judge or jury. We'll talk about that in the next module. But the problem here, there's two problems. Fashion designs. The one thing that you cannot copyright is a fashion design. So for example, I'm wearing this tie that my wife got me. It's a Ralph Lauren tie. I'm a huge polo guy. So anybody's free to make a tie. Anybody can make a tie with this identical design. What you're not allowed to do, of course, is maybe, you can't use, there's no polo copyright trademark on here, but some polo ties will have the polo trademark. You know what I mean? Like the trademark is, or like, think of a pair of jeans. That's a better example. I don't want to show you my butt, so I'm not going to stand up, but I'm wearing like some, Levi's jeans. You know what I'm saying? So anybody can make a pair of jeans, right? But only Levi's can use the trademark to distinguish their pair of blue jeans, from, let's say, whatever, who else makes jeans, Seven or whatever, the other popular jean, the Gap, other jean manufacturers, and retailers. And here's the problem, right? You could argue, and this is why most tattoo artists do end up settling out of court, because if I'm a judge, right, I might accept the analogy that a tattoo is more like a fashion design or a fashion accessory, and therefore it's not copyrightable, to use the popular formulation. So will the courts buy that analogy to fashion designs? But there's actually a deeper problem, and it's really based on public policy. When we talk about Napster, we'll talk about that in the next survey question. When the court concluded that Napster had been infringing on intellectual property rights, the copyrights of the music labels, what did the court do? It ordered Napster to take down all those music files, right? Basically, that's why Napster went out of business, because 99.99% of the MP3 files that were on the Napster servers, right, or on the Napster system, those were all copyrighted materials, right? So they had nothing left once the court ordered. So imagine now courts were to say you can copyright a tattoo, and imagine now I'm alleging Mike Tyson is, violating and wearing sporting a tattoo that I designed. What is the court going to do? It's going to award me damages, but is the court going to also, issue an injunction or a court order requiring Mike Tyson to remove the tattoo? That's very dangerous territory. You know what I'm saying? We're talking about, court orders and injunctions are punishable by civil contempt. You can get thrown in jail until you comply with the court order. And so I have to tell you personally, and by the way, time out. This is exactly what Oliver Wendell Holmes meant in Module B when he said the common law is not based on logic, it's based on experience. Yes, logic would tell us that tattoos should be, copyrighted, could obtain copyright protection to the extent they comply with the literal requirements of the common law or federal Copyright Act, right? As long as your design is original and you can affix it on a tangible medium of expression. But in the case of tattoos, where the tangible medium of expression is human skin, and it's part of your persona, your identity even, you know what I mean? That can get into very dangerous territory, very dangerous waters, because we theoretically have the power to compel people to remove, their infringing tattoos. And if they don't, they get thrown in jail under civil contempt for not obeying the court order. So that, my own opinion here is that when this does go up to the Supreme Court, or when the courts finally decide to address this question, probably I think they're going to analogize tattoos to fashion designs. Think of Justice Ginsburg's majority opinion in Yates versus how is it that a fish is not a tangible object? Because Justice Ginsburg said we have to look at the purpose of the statute. And the Sarbanes-Oxley Act was designed to deal with crooked and corrupt accountants. It wasn't designed to deal with the problem of, undersized fish in the Gulf of Mexico. You know what I mean? And so she was looking at the purpose of the statute. And so, you have different, so it's hard to predict how this case will come out. Both answers, by the way, from a perspective are correct. You could argue by analogy a tattoo is like a fashion design. You could argue literally the tattoos comply, as long as they're original, they comply with the Copyright Act requirements. But it's hard. It's a real hard issue. And let me tell you, dozens of law review articles have been written about this, and even scholars don't agree on what the court should do here. So it's a real tough question. All right, this actually takes us, speaking of infringement, this takes us to the Napster case. Now, what I'm going to do here is I'm not going to belabor this old case, except to say that this is actually, from a historical and precedential point of view, a really remarkable case. Because if you know anything about startups, you'll know that maybe I think Twitter, it took them like almost 3 years to get like a million users. Now Twitter, of course, is very popular. YouTube. It took YouTube a number of years also to get 1 million subscribers. Now YouTube is very popular. I dare say, regardless of how you answered that first survey for Module A, what social media website you use the most, I dare say that you use YouTube just as much as you use any other website as well. But Facebook actually was probably one of the fastest. Facebook, they got 1 million users in under a year. So that's actually pretty remarkable. Napster got 26 million users, in their first year of operation. I mean, Napster was probably the most phenomenally fastest growing successful company, in recent memory. And yet, when the record labels decided to sue Napster for copyright infringement, right? They're going to lose that case. Napster's going to lose that case. And when the court issues the injunction and awards damages for every act of infringement, so now we're talking about $2,500 per song that's played each time. We're talking about literally not millions of dollars or tens of millions of dollars, or even, now we're talking about hundreds of billions, potentially billions of dollars of damages. And worse yet, we're talking about an injunction, a court order saying that you cannot continue to allow your subscriber base, to share these copyrighted files anymore. So here's my question, though. I don't want to belabor the past. I want to emphasize it's why you need a lawyer, right? Because that was otherwise that would have been a very successful business model, right? But how? Let me just put it bluntly. How the hell is YouTube any different from Napster, right? In many ways, I could argue YouTube is worse, because when you use YouTube and you upload something on YouTube, it goes to YouTube's or Google, they own YouTube now. It goes to YouTube's own central servers, right? YouTube, Google, Alphabet Inc., right? They're actually storing on their servers potentially, all this copyrighted potentially infringing material, right? With Napster, at least, when you downloaded the Napster program, what it allowed you to do was to access other Napster users' music files, and they could also, by reciprocity, they could access your music files via the Napster program. So Napster was just facilitating file sharing. YouTube actually stores potentially, infringing. So how is it that YouTube is still in business, right? And so what you're going to see here are 4 answers that each of them are actually. Let me expand this a little bit better. Let's see if it let me expand it. The first answer here, all of these answers are potentially correct, but I'm going to say some of these answers are better than others. This first answer, that 27% one quarter of the class, a little bit more, voted for. It's probably the weakest answer, because this was Napster's defense. When they did finally get sued by Metallica and then by the A&M Records and the other big 4 or 5 record labels, they asserted fair use and they lost on fair use. And you can see why they lost, by the way, because look what happened as soon as Napster was launched in 99. Actually, you don't see 1999, but 99 was like 14 billion then in CD sales. That was the peak. That was peak CD sales for the music industry. And now look what happened, right? It started plummeting. Look what happens when when YouTube, they make a recovery when Napster shut down finally. Then in 04, 05 here, YouTube comes along, and then now you even see more dramatic decreases in CD sales. So one of the factors of fair use, is it fair use for me to play Shakira at the beginning of the thing, or to show copyrighted stuff? I could argue it's educational, but that's only one of the 4 factors. I have to look at how much of the copyrighted work that I'm borrowing or stealing, as the case may be. I have to look, what is the nature of the copyrighted work? Is it commercial in nature, proprietary? I also have to ask, what effect on the market of the copyrighted work does my act of theft or borrowing have? Now, I say this because fair use, if you can prove it, it does allow you to steal, just to put it bluntly. It does allow you to take stuff that doesn't belong to you. But proving something is fair use is going to be an uphill battle, whether you're Napster or YouTube, because you can see that once these companies were launched, you see, and I'm not saying it's a correlation is causation, but, this is going to be hard to explain away, right? And Napster learned that the hard way. They asserted fair use, and the court rejected that defense because they saw significant declines in the sales of CDs. Now, you could argue Napster had some expert testimony saying that CD sales are going to decline anyways with the rise of the MP3 player. People would start buying, downloading music via iTunes and not buying CDs anymore. So Napster, to me, actually had a very strong case, though the courts ultimately rejected their fair use defense. And I'll tell you, that's generally the biggest problem with fair use. It's hard to predict ahead of time how a court is going to come out with all four of the factors. The second answer about the lawyers, let me tell you, at the time, like YouTube, at the time YouTube was launched, YouTube was a small company. Google doesn't buy YouTube until much later, right? So if anybody had the best lawyers, it was really A&M Records and the other big record labels. We're talking about major conglomerates like Sony Entertainment, Columbia Records. These are owned by other companies, Sony and Columbia respectively, that are part of these larger entertainment conglomerates. So trust me, yeah, now Google and YouTube has some of the best lawyers, and they can go toe to toe with A&M Records and Sony Records and Columbia, et cetera. But back then, probably the record labels, were able to afford, the best lawyers. So probably that's not going to be. We'll say more about that in the next module when we look at litigation. Look at the last two answers. These are the best answers. Look at this one about this takedown notice. This is really the main difference between YouTube and Napster. And it's why YouTube is not only in business, it's thriving. One of the most valuable, next to Google search, it's probably the second most valuable part of Alphabet Inc.'s intellectual property, right? Because YouTube is very popular and justifiably so. But here's something I want you to know about copyright law. It's a very important amendment that was enacted by Congress in October 1998, just a few months before Napster was launched in June 1st of 1999. In October 98, the Congress enacted and President Clinton signed into law something called the DMCA, the Digital Millennium Copyright Act. What that law does is it says, look, actually, this is a very historic, to me, it's probably the single most important piece of intellectual property legislation for the following two reasons. One is it says to the world, copyright law henceforth shall extend to the internet. If you had this libertarian utopian dream of the internet being completely open access, you can do whatever the hell you want, you can borrow and take and steal whatever you want on the internet, those dreams are now dead. Congress has now, as a matter of public policy and federal law, declared that the copyright law and copyright protection shall extend into the internet, into the cyberspace, and that sets a great precedent. That means trademark laws will now be protected as well. Trade secrets and patents all will get protection in the virtual world, not just in the physical world. But here's what the DMCA does that's different from those other areas of law. The DMCA, it puts the burden, both the financial and legal burden of proving the infringement and going after the infringer on the copyright owner. If you want to allege copyright infringement over the internet, you now have to do two things. You have to send a takedown notice to the alleged infringer and to the platform which is hosting the infringed material, whether it be a music file or a video file or a published work. And you have to give the alleged infringer, and notice I say alleged, because you have to give the alleged infringer a reasonable opportunity, time, to decide whether they're going to fight back and assert fair use, or whether they're going to take down the infringing material without any legal penalty. The takedown notice procedure created by the DMCA, in other words, creates what lawyers call a safe harbor for potential infringers. Because now it's up to the record labels. It's up to the Hollywood studios. It's up to the New York publishing firms. Now they have to hire a bunch of people, right, to scour the internet, scour YouTube, scour all these websites, find out, okay, who's posting material without our authorization, copyrighted material, and then hiring a lawyer to send out a takedown notice to the infringer, and giving the infringer a reasonable time, a reasonable opportunity, right, to respond, to either take down and avoid legal liability, right, or say, no, you know what, I challenge takedown notice. I'm going to, sue me, and I'm going to assert the fair use defense in court, and we'll fight it there like Napster did. So notice that, and this is what YouTube does, right? You probably, we're going over time here, so I won't show you some examples, but you've probably been on YouTube and, you see a gray screen and it says this stuff has been taken down, because we received a takedown notice. Google, YouTube, actually, they have their own algorithms, and sometimes a lot of times they'll take down infringing copyrighted materials without even waiting for the takedown notice. So YouTube, in other words, is not just responsive to takedown notices. If they get something from Metallica, right, they'll take it down right away, no questions asked. And sometimes they'll just take it down ahead of time just to show in good faith, hey, don't sue us, we're taking stuff down. As soon as you send us a notice, or even we'll do it ahead of time based on our own machine learning algorithms. So, and Napster, of course, that's not what they did, right? They just ignored the takedown notice. Napster would just give a big middle finger to Metallica, a big middle finger to A&M Records and all the other record labels, right? And they said, we're going to challenge the takedown notice under the fair use exception, and we'll take our chances in court. They gambled the company and they lost, right? Now, notice this last option. It's also probably correct and true. Actually, if you go to YouTube, let's do it because it's kind of fun to do this. Metallica is they brought a lawsuit against Napster, and when they won quickly, because federal courts do tend to be quicker than state courts, that's when A&M Records piled on, and the other, all the other record labels. I'm trying to open up YouTube here. If I'm not able to do it, we'll just move on. My internet is a little bit slow. Okay, here we go. So let's go ahead and let's pull this up. I'll do a search here. My internet is a little bit slow, so I'm taking a risk here. Metallica, and what you're going to see is, YouTube will link to, Metallica paid YouTube to put their official Metallica webpage on the top of the search results. But then look at this. Look at this here. There's this Music Box PH. Who the hell are they? Why are they posting Metallica stuff? And why hasn't it been taken down? And look at this. It's even better. Look at this. Metallica has their own official channel on YouTube. And that is pretty much, and I think some heavy metal is about to load here. But sorry, we got an ad instead. But to go back to the survey results, what YouTube does as well, say, look, not only will we comply with the takedown notice, if you send it to us, and not only, but we don't want to get a takedown notice, right? Because we're YouTube, right? We'll get more people using our website if they can access Metallica on our website. So Metallica, I'll make you a deal. Why don't you host your channel? Don't send us a takedown notice, and host your official channel. And every time somebody downloads a Metallica song, like I just tried to do, and a stupid ad pops up, we're going to give you a cut of that ad revenue, right? So that is a master plan. That's what Spotify does now. They're going to license the music and legally share the files, right? Just a brilliant move by YouTube, right? So YouTube is opposite from Napster in that they comply with the takedown notices, they comply with the DMCA, and number two, they've worked out a deal with a lot of these record labels and musicians to say, hey, don't even send us a takedown notice in the first place. Let's work out a deal where we will share our revenues with you, and you keep your stuff up and don't take down the other stuff that other people are posting as well. Because we want to have more people on YouTube, and if we have Metallica on YouTube, we'll get more people on YouTube who like heavy metal, and want to listen to Metallica. It's actually a really good band. I think Black Sabbath is a little bit better, if you ask me. AC/DC is probably the best, you know what I mean? But we might have different taste in metal music. All right, so let's do our last two survey questions here, and let's move on to trademark law, because we're now over the hour. So I just want to do trademark law. This was an easy question. Which of these are not, which of these do not receive trademark protection? And the answer is, none of them. They all get trademark protection. The thing about trademarks, and these are some beautiful examples in here, and I'm sorry, when I make it larger, for some reason on Canvas, the image gets distorted. But you can see some of these trademarks here, and I'm sorry that Canvas will distort the image a little bit, because these are, I consider this beautiful. I consider it almost works of art. You know what I mean? I love going, whenever I go to a new city, there's two things I've got to do. Visit a bookstore, a used bookstore, and just, find a book that I've never even expected to find. And I have to go to that city's art museum, no matter how small it is or how obscure it is. Those are the two things I always do whenever I go to a new city I've never been to. And I think trademarks are a lot like art. They're just so beautiful. And how do you get a trademark? Your trademark just has to be distinct. Now, the easiest way to get the trademark is I'll use the Google, because we started with the PageRank algorithm, and I want to end with Google. Like the word Google, there is a concept. Let me go to Google search. There is a word in mathematics called a Google. It sounds basically identical. It's a one with, like, how many zeros is this? 100 million? Like this is a huge amount. You know what I mean? A huge amount. It's a one times 10. It's a logarithm here, but it's a huge amount of zeros. So it's. But the word Google, spelled this way. Let's go back to Google search. It's spelled Google, right? Completely arbitrary and fanciful. So if you go back to my survey questions, you'll see a few of those, like the word, or the Apple logo, right? That is, to describe like a personal computer, and now iPods and smart iPhones, completely arbitrary and fanciful label. But notice what you see here. You see some things like the word, like you see a lot of names here, like Disney, Louis Vuitton, JP Morgan, you even see initial UPS, the letter F, right, for Facebook, etc., H&M and Sada, or, in Spain, they say Thada, the Z has a different sound to it. Point about it is that the other way you get a trademark is what lawyers call secondary meaning. If your mark is so famous that in the mind of the average consumer, they associate your mark with your products and services. So, for example, Sada, which is a common name in Spanish, although it's normally spelled with an S, but I've seen it spelled with a Z. But when you see the logo, that's a fashion store. Chanel, you know what I mean? That's Coco Chanel. That's a logo that you automatically think maybe of a Chanel number 5 or all the other Chanel bag, the fancy products that they make. Budweiser, but this Bud's for you. Or I'm loving it, or the M, right? You can even trademark a color. So UPS, for example, the color brown on its delivery vans, right? UPS owns the trademark for that, because, on a delivery van, if you see a brown van, of a certain shape, you're going to think of UPS, United Parcel Service. Or for the ladies, the fancy Louis Vuitton red bottom shoes. So the Louis Vuitton, the owners of that company have trademarked that shade of red for the bottom of their ladies' high heels, stilettos and whatnot, So, the key is that, and this is so important in the business world, branding, right? In economic theory, right, economists assume what's called, perfect competition when they're not studying oligopoly or monopoly. Perfect competition, you assume multiple sellers with homogeneous products. What branding does, what trademarks allow you to do, is destroy economic theory. To have, and if you see the rest of the Peter Thiel interview, or you read his book 0 to 1 on startups, that's exactly what he's talking about. A successful company builds a tiny little legal monopoly, over its products and services. And how do you do that legally? By branding. So that, when you think of, like, you see the Coca-Cola logo, or you see Coke is it, have a Coke and a smile. If you saw the Mad Men series, back when it was popular, that you associate with Coca-Cola, right? So it's like, so look at, and this is just a small selection But all the successful companies, all the Fortune 500 companies, all the successful startups, one of the things that they have is not just good products and services. Because remember Peter Thiel, I know he's smug, I know he's arrogant, I know, I don't like him either. Let's put it that way. But guess what? Just because you have a good idea doesn't mean you're going to be rich, right? A lot of inventors, starting with Nikola Tesla, died in poverty. They weren't able to do what Edison did, commercialize their ideas using intellectual property law. General Electric, that's one of Thomas Edison's initial, famous trademarks, when the General Electric company was established. Think about that, right? How am I going to distinguish my light bulb from your light bulb, right? A light bulb is a light bulb. I could argue that my light bulb is better than yours, but ultimately, if I have a beautiful trademark, that can create goodwill with the public and loyalty with my consumers, And so it's trademarks. I can't tell you enough that it's really probably of all of these areas of property law, because even if you don't have a trade secret or a patent, even if you don't bother to register your copyrights, but if you or I should put it another way, even if you have valuable patents and trade secrets, even if you do register your works under copyright law, if you don't have a brand, if you don't have a mark that's legally protected that only you can use, that helps to distinguish your products and services from those of your competitors, it doesn't really matter. None of that other stuff matters. You have to have a brand. You have to have a way of distinguishing your goods and services, and that kind of goodwill, that psychological loyalty you're trying to create with the people who are buying or using your products and services, that's what trademarks allow you to do. It's just a magnificent thing. Now, getting a trademark is somewhere in between getting a copyright, which is really easy, and getting a patent, which is really hard. To get a trademark, you have to go into something called the Electronic Search Service, or TESS, that's run by the USPTO, the US Patent and Trademark Office. And to get a trademark, you have to first figure what type of good or service you're going to mark. You want to get a trademark for, or service mark. And there are like a number of several dozen different classes of trademarks, for different goods and services. So that's the first thing you have to do. And, it's helpful to have a lawyer to do that, and then to do an actual trademark search and figure out, because, yours, the standard for trademark infringement it's not originality, your standard is your mark, is there a substantial likelihood of confusion with any other existing mark? So you may have heard, for example, that Kylie Jenner, I believe her name is, she has this tequila brand, I think it's called 818, and she's been sued by the owners of a tequila brand called 512. And so for trademark infringement, for basically that the 818 trademark creates substantial likelihood of confusion in the minds of tequila drinkers, from the 512 mark. And so you can Google that and look that up for yourself. I don't want to take any more time. I still have one more survey question. That's something that would have to go to the courts. I suspect they're going to settle that out of court. We'll look at that. Maybe we'll talk about that case in the next module. We'll see what happens there. But just to give you an example of how important trademarks are. Now, what's really interesting, one more interesting thing about trademark law. Oh, by the way, trademark, although there is something called the Lanham Act, which is a federal trademark law. Trademark law, it's based on the common law. So you don't have to register your marks to have legal protection, at least under the common law. But federal registration has a number of advantages over common law trademarks. The problem with common law trademarks is, go back to Mark Zuckerberg when he launched the Facebook. He first launched it at Harvard exactly 18 years ago in February 2004. And then by the end of this month, 18 years ago, he launched it at Columbia University and at Yale College in New Haven and the Upper West Side in New York City. So under common law trademarks, you only get protection of your marks only in those markets in which you're doing business. With federal registration, even if you're only doing business in one or two limited markets, you get nationwide protection for your trademark. So trademark registration is very, very, very powerful. And you get a federal court, federal jurisdiction to enforce your trademarks. The other big advantage with a federal registration is that as long as you're using your marks in commerce, you can get, you can renew every 10 years your trademark registration. So it works almost like a trade secret in that, as long as you're using your trademark, you can continue every 10 years to get your renewal. By the way, that's why you don't see Mickey Mouse. I don't have him here, but you have Disney. But like the Mickey Mouse copyright, which is finally going to expire next year in 2023, after Congress enacted the Sonny Bono Copyright Protection Act, which should really be called the Mickey Mouse Copyright Protection Act, right? Because it gave corporate owners of works an extension of 25 years, from 70 to 95 years, right? That they own their copyrights. Doesn't matter, because guess what, y'all? Disney has also trademarked, right? Has registered Mickey Mouse as a registered trademark. And as long as Disney is using Mickey Mouse to sell merchandise, or using Mickey Mouse to sell, TV shows or whatever, as long as Disney continues to use Mickey Mouse in commerce, right? That's the one thing, you have to use it in commerce. Then Disney will continue to own the intellectual property rights in Mickey Mouse, even when the copyright expires. Again, lawyers will help you figure that out. Can I also copyright my trademark logo, or can I trademark my copyright logo? There's different requirements. We've talked about it generally here, but it really does depend on the type of product and service and a lot of other factors. Finally, the last interesting thing, and the last survey question here is, has Google become a generic mark? This is one of the most interesting things of trademark law, because it's the one area of law where you get punished if you're successful. If your mark is so successful that it is synonymous with the product it's describing or the service it's describing, it becomes generic. And look at these results, right? Most of the class, almost 3/4 of the class, would come to the conclusion by now, 2022, Google is a generic mark. Now, what's interesting is I've included in the textbook a case. I'm the co-author. That's one of the chapters I wrote, chapter 24. I've included a case in Arizona, a federal case, where the court reaches the opposite conclusion, right? And to me, I think that should have gone, to me, I disagree with that court decision. I'm wondering if it was one of those judges who has his secretary, print out his emails. I'm wondering if it's even a judge that even uses email or even knows what Gmail is, et cetera, Google search, et cetera. But I think if that case were to be brought again, I think it would go the other way, But anyways, other examples of marks that lost their trademark protection. The word Kleenex, that used to be a valuable trademark to describe tissue paper, right? But now it's become generic, so anybody can use the word Kleenex. The word Frisbee, by Hasbro, was owned by Hasbro, but now it's become generic to describe any kind of flying saucer, recreational sports thing. You know what I mean? Now this is why you have to have a business lawyer, because Google. Even if Google becomes generic, or even if now, for all practical purposes, Google is generic, the next time this comes to court and the court agrees with us, I agree with the class, by the way, that Google, it's a generic mark. But guess what? Even if I'm allowed to use Google to describe my own internet search service, guess what I won't be allowed to do, right? I won't be allowed to really, I can tell you, Google has this copyrighted as well, kind of the reverse Mickey Mouse. So I won't be able to infringe on Google's copyright. In other words, I might be able to use the word Google, but I won't be able to use this particular copyrighted logo with the blue G and the red O and then the yellow O and the blue lowercase g and the green L and the red E, So that's, so notice what's going on here. I'm going to close on this, right? Notice that the big companies, they use all 4 areas of intellectual property law of ideas to protect, their brand by using trademarks and copyrights, right? And their underlying inventions, ideas, and improvements to their products and services using patent or trade secret law or some combination of both of those. So that's why ultimately I will tell you, Peter Thiel is completely correct in saying that, it's not enough to have a good idea for a product or service that's essential, right? That's a necessary condition for success, but it's not a sufficient condition. In addition to that, and here's where this class comes in, you have to own the intellectual property rights to your idea or to the expression of your idea or to the branding of your idea, or ideally to all three, right? And so again, that's the lesson that we learned from the previous class, the common law, and the previous class to that, sources of law, right? The law is complicated and messy. A lawyer is a necessary business expense just to keep you out of trouble, right? But in addition, a lawyer is a necessary business expense so you can use the law in a very positive way, to actually, get the value from your ideas or from the ideas of the employees of the company, right? Somebody has to own those ideas. And so it should be the owner or the company, right, who hired the employees who came up with the idea. That's what intellectual property law allows you to do. And that's why it's so important. And that's why companies like Google, Amazon, Apple, it's why those companies, their shares are like over $1,000 a share, right? Because they own valuable intellectual property rights in their ideas, right? In their PageRank algorithm, for example, that we saw in this class, or in the Apple logo that I showed you in the, in the one of the survey questions. Okay, great. With that, this lecture is now formally concluded. So I will end the recording, but open it up to questions, comments, concerns about any aspect of the class. Yes, you're welcome. And of course, everyone is free